Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel we answer publicly posted questions from YouTube users getting focused answers they need from an employment attorney. We have a question here from YouTube user James WS9ZE who says, excellent content. James, I think you have great taste. James goes on, I discovered your channel about a couple of days ago and I've been sucked into the rabbit hole of employment law. It's dangerous. You can end up being an employment attorney that way. Could you do a video about whether or not teachers have a case because they cannot use the restroom all day because they have to teach all day long without a break except for a 30-minute lunch break, really less than that even because they have to accompany the students to and from the cafeteria, which eats into the teacher's lunch break. This is especially problematic for those with urinary problems like an enlarged prostate and those without alike. Keep up the great work. Okay. So most teachers are union employees and they have collective bargaining agreements. And generally your collective bargaining agreement will set out your rights vis-a-vis breaks. In many jurisdictions, those collective bargaining agreements might supersede the state rules on breaks. That's not always the case. So check with local counsel where you are about your rights for breaks under state law. Now, you can also check with the union about your rights for breaks under the union agreement. And that's all going to be basically the answer if you don't have a disability. However, if you have a disability or a pregnancy that causes you to need additional bathroom breaks, it's a whole different world. We're going to talk about the federal laws, but it's worth noting wherever you are, you might have additional rights under state laws or even local laws. So check with local counsel. In all 50 states, Puerto Rico, all the protectorates, all the lands of the United States, if you have a disability, you're due a reasonable accommodation. That is the law of the land under the Americans with Disabilities Act. And if you get a reasonable accommodation letter from your doctor, immediately someone in the comments is going to say, you don't need a letter. Okay, I'm not going to have that argument with you. Nobody's going to take your case if you didn't get a letter from your doctor. That's just the reality. Generally speaking, most of the time, if you don't get a letter from your doctor, it can introduce so much risk into a case that it can be hard to find counsel. I can think of one case this year that I liked enough to take without a reasonable accommodation letter from a doctor. One disability case, right? That speaks volumes, right? Now, let's assume you do things right. You get the reasonable accommodation letter from your doctor. You take it to your employer. You say, hey, I have a disability. I need a reasonable accommodation. I need some additional bathroom breaks. It is going to be very unlikely that they can argue that's not reasonable. All they really have to do is have a para or an administrator step in your room, watch the kids. You go to the restroom for, I assume, 10 minutes, and you return. Boom, you've been accommodated. We can do that twice a day. It's still reasonable. I would argue you could do that 4 times a day, and it would still, in fact, be reasonable. There's a limit, right? If you need it if you need a bathroom break every 20 minutes, that could be onerous, right? It's almost like they have to hire an extra person just to give you your bathroom breaks. That would be problematic, right? But you get the drift. So, listen, urinary problems, enlarged prostate, diabetics, pregnant people, people who have had various forms of cancer, bladder cancer, urinary tract issues. There's a million different things that can cause you need additional bathroom breaks. And frankly, we've litigated them all because for whatever reason, employers are super weird about the restrooms sometimes. And you always know when you see that, when you see an employer being weird about the restroom, they're going to act crazy during the litigation. Crazy meaning zany, not crazy meaning mentally unwell. And when they act zany during the litigation, it benefits you and you end up winning more because their irrational behavior kind of undermines their attorney's ability to defend themselves. So I know this is common to teachers. Many teachers have trouble getting bathroom breaks. It's very normal. But if you're bringing this up and they're fighting you on a reasonable accommodation, that's probably a valuable claim. There's not too many judges, juries, or arbitrators who are super thrilled to hear about how the employer wouldn't let you urinate. That's just like a human need, right? Like, there's a lot of people who are like, oh, you don't have to eat every 8 hours if you don't have a medical condition. Why? You don't need a lunch break. There's a lot of people who feel that way. There's almost no one who's like, yeah, why would you need to pee? Right? Like, urinate? Why would you have to do that? Like, we're pretty much all like, yeah, that's a human right. That's just like a basic thing that you need to do to get through your day. Not doing it can cause like harm to your body and also can like make you a less effective employee. So it's just really stupid to keep employees from bathroom breaks. But that being said, they can't keep you from bathroom breaks if you have a disability, as long as your accommodation request is reasonable. So, James, I hope this answers both sides of your question, because if I understood your question, you were asking both for people with a disability and those without. And so I tried to split up the answer into two parts. If you don't have a disability, check your local state laws and your local statutes, but also your collective bargaining agreement as per your rights, or even your contract, right? If you are working without a collective bargaining agreement, you're not unionized, you're going to be subject then to the state and local laws, but also potentially have some breaks written into your contract, although not always. Often contracts don't include it in the way that a collective bargaining agreement might. There's also, listen, not every collective bargaining agreement has breaks in it. I'm going to be upfront with you. That's not always the case. So it is possible that you start looking into your rights and they're not great. So that's not ideal if you don't have a disability. If you do have a disability, I'm sorry you have a disability, but you do at least get extra rights under the ADA and potentially under state and local law as well. You're due a reasonable accommodation dialogue. You're due any accommodation that is reasonable. And I would recommend to you, we have videos on the channel about getting your reasonable accommodation letter from your doctor and getting it turned into your employer and engaging the reasonable accommodation dialogue. I would recommend you hit those up and take an informed approach to perfecting your rights and protecting your rights. And yeah, listen, I can be hard on teachers. I know that, right? But teaching is a hard job as well. And there are not enough breaks. They play very fast and loose with prep periods. Administrators are often predatory towards teachers. It can be very, very hard to be an educator in the United States. Frankly, in most of the country. In part because of crap students like me. I was not a particularly kind student to my educators. I had some really great relationships with a couple of teachers. I had a Latin teacher who I thought I looked up to a great deal. I learned a lot from him. I had a political science professor that I looked up to a great deal. I think we've done a collaboration on the channel with him. But by and large, I was a poor student with a poor attitude and poor behavior. And sorry if you were one of my educators. I'm sorry. But anyways, I digress. James, these are your rights. I hope it helps. If it does, like, subscribe, comment down below. Share our channel so it can grow. Take care, everybody.